Blessings, fam. So I want to continue. This is part 5 of Christians Alliance versus Noemi Soto, me, hashtag BG2G, bringing glory to God, on this discrimination case and how the judge starts showing his true colors, corrupt colors in this case. And so we went through the beginning, the discrimination, just kind of everything. And now we're at the judgment. So I'm going to be sharing the PDFs that all involve, and I'll be talking in the background. And so what you see here is the judgment for dismissal. This is what popped up. This is what I initially saw after we were supposedly heard by the judge. Like, we basically, I didn't know what to expect. I basically read verbatim my conclusion to my written memorandum of law in opposition to the motion to dismiss. And the judge, at one point, he even kind of snickered at me. Towards the end, he did not make any ruling or anything at the time. He just basically said that he had 60 days to decide. And I was like, well, we have a scheduling order and that has a time frame, and what's going to happen with that? And he was like, well, whatever. He ended up ruling this, and this is what we got August 22nd. Okay, the foregoing have been considered by the court is hereby order granted the disposition, the judgment of dismissal. And this is what the judge says. The plaintiff's complaint alleges employment practices that are in violation of the Connecticut Fair Employment Practice Act. Claims under this act are within the purview of the Commission of Human Rights and Opportunities. It is undisputed that the plaintiff did not obtain a release of jurisdiction from the CHIRO, that's this one, Commission Human Rights, before bringing this action. The plaintiff's failure to exhaust her administrative remedies deprives the court of jurisdiction to hear her claims. See Sullivan, Board, blah, blah. Judicial notice was sent regarding this order. That's it. None of my argument, it says undisputed, so I did not dispute the fact that I didn't have a release of jurisdiction, but I absolutely disputed the idea that the court did not have jurisdiction. They did have jurisdiction. And this judge, Edward Domnarski, just didn't want to do his job. Basically, he didn't want to serve the people. He didn't want to serve and do his job as a public servant in this case. For whatever reason, he was just a jerk, in my opinion. And that was a shocker. Initially, that was like a huge shocker for me. I did not expect that a judge would deny, like what I said. Even the other lawyer, the defendant's attorney, was, put in a motion for extension of time to reply to the summary judgment, because even in his understanding, I had a case. Like, so this judge is just a jerk, and he needs to be fired and not be a judge. The other thing that I want to show you guys is under the Connecticut practice book. So this right here is the Connecticut 2018 practice book. This was what was in effect during the time of all the motion to dismiss and summary judgment. And I want to read to you something that is clearly stated here, right, regarding judicial decisions and judgments, right? So it says here, the judicial authority shall state its decision either orally or in writing in all of the following: in rendering judgments and trials to the court in civil and criminal matters. So this was a civil matter, and Judge Edward Domnarski rendered a judgment of dismissal, and his explanation deliberately omitted my entire side of the argument. The most important statement here that I want to highlight is that the judicial authority's decision shall encompass its conclusion as to each claim of law raised by the parties and the factual basis thereof. This judge did not want to address the fact that I argued that he did have subject matter jurisdiction. He completely ignored it and omitted it because, for whatever reason, some unjust reason, some selfish, self-centered, egotistical reason hindered him. I don't know what else could have deterred him apart from laziness or a conflict of interest of some sort in not wanting to hear my case. The other thing that I want to talk about in this process, right, is that at the appellate level, so that was the judgment, I'm just going to close that off. At the appellate level, I was supposed to draft a judgment file. And I never heard of this, and I ended up having to look at statutes and stuff about a judgment file and how that was supposed to, I had to draft it. And so basically, this was my draft of the judgment file. Date of judgment, according to everything that I read, I basically wrote a history of everything that preceded in this case. So the claiming of disparate treatment, the following is a list of filings and events in the order in which they took place. You see the defendant submitted the agreement of the proposed scheduling order, the case status conference, the proposed schedule, defendant submitted motion to dismiss with a memorandum of opposition, defendants submitted withdrawal, and with a memorandum of law to support all this motion of summary judgment. You see how that was like same date, same date. Plaintiff responds to motion to dismiss. I was quick on that, just several days, 706. Under the scheduling order, responses to dispositive motions were due to be filed on by the 31st. And defendant submits extension of time. Plaintiff responds. I actually had filed a motion to strike request for extension because I thought that was just rude. Honestly, I felt that if I had a certain amount of time to respond to his motion to dismiss, that he should have allocated the same amount of time to respond to my summary judgment. Plaintiff filed with court a reclaim for motion of summary judgment. Oral argument hearing was heard only for motion to dismiss, not for everything. A judgment of dismissal was granted in favor of lack of subject matter, whereupon it is adjourned. And basically this was the quote that the judge had entered, the plaintiff failure, So I drafted that, and then I submitted that to the court clerk, and the court clerk basically shrunk everything to just this. Is a one-pager. She or he, I don't know who it was, right? Basically said, this judge, honorable, I don't think he's honorable at all. This action by writ claiming damages came to the court, blah, right? Return date of December 19, and thence on December 20, when the defendants appeared, and thence on March 22nd, when the plaintiff filed motion for injunction, and thence June 22nd, when the defendants filed a motion to dismiss, and then on June 26th, and they have this wrong because the defendants, June 26th, anyways, when the plaintiff filed a motion for summary judgment. The court, having heard the parties on August, granted the defendant's motion to dismiss. And dismissal entered on the 22nd, whereupon, whatever. So as you can see that there were things here I felt, I don't know, were like omitted. about to what exactly happened in this case, but I don't know if that is how it's supposed to be. I'm not a lawyer. I'm winging this, but I don't know. I think this is also a place where perhaps corruption is done because if you omit things and this is what the chief clerk signs, you know, I wrote a thorough one and then she condensed it and omitted information and signed that. This is possibly a process that much corruption gets done under. So with that, basically, family, that just kind of ends those thoughts and comments, Justice Diaries, on that area. Next up is the actual appellant brief that I submitted.